The town flake stood to speak. He is an old and adult gentleman with hair in long white tangles, wasp dreadlocks. He's been making a complete and utter pest of himself at town meetings for over 30 years. He owns his own mimeograph machine and runs off reams of smudgy philippics accusing town government of incompetence and waste. He knows all the regulations in Robert's Rules of Order and uses them until he has to be shushed by the moderator and shouted down by the townspeople. And he is always and invariably right on every issue. Save money in the long term. Save money in the long term, said the town flake with high scorn. Government's always full of ideas to save money in the long term. Just why is it that government never has a single solitary idea about saving money now? The town flake was shushed by the moderator. Well, that is from the 1991 book Parliament of Horrors by the late, great P.J. O'Rourke about how town council meetings work in his little town in New Hampshire. I was reminded of that by reading the cases for this week's show, where we're going to be talking about other town and city council meetings and whether arresting someone like the town flake who speaks at one of them would violate the First Amendment. That this week on Short Circuit, your podcast on the federal courts of appeals. I'm your host, Anthony Sanders, director of the Center for Judicial Engagement at the Institute for Justice. We're recording this on New Year's Eve, 2024, but the show will be coming out a couple days after New Year's. So Happy New Year, everyone. Welcome to 2025. With me on the show today are a couple Institute for Justice attorneys to talk about these town council cases in a moment. First of all, though, it being the last show of 2024 or the first show of 2025, whatever you want to say about it, I thought we should note on Short Circuit something we have not talked about since last couple months, and that is the passing of William Chip Mellor, IJ's co-founder and president for many years. Now, IJ put out some statements when Chip passed away a couple months ago. Many of us who worked with Chip, including myself, have said things in other media. So we very much noted his passing. But I wanted to make sure before the year ends that we say something about him here on Short Circuit. Now, as most listeners who know a bit about IJ know, Chip was the co-founder of the Institute for Justice, along with Clint Bullock, back in 1991. He was then president of IJ for a very long time, until 2015. In fact, he was president until today, December 31st, which was his birthday, 2015. And he retired as one does at the age of 65. Many founders would go on and keep running the organization, but Chip understood he was building for the future and wanted to make sure he handed off the organization to the next generation. So he retired as president, and then he went on to serve as chairman of the board, where he served until really shortly before his passing. As many of you know, there would very much not be an IJ without Chip's leadership. So many things that IJ does are, of course, owed to him. He also worked at a number of different organizations, including in the federal government, before he was at IJ. And many people who have written elsewhere upon his passing have detailed all the great things he did there. I wanted to note specifically what Chip was like as a boss. I worked under him as my ultimate boss the first 5 years or so I was at IJ. And the thing that he would tell people on the first day of training is, don't get too comfortable at IJ. And, us like new attorneys or new staff members would kind of be like, oh, wow, what's going on here? But what he meant by that was not that you could be fired at a moment's notice, but that if you get to a place in working for an organization with a mission like IJ, and you get to a place where you're comfortable and you don't feel, you really have any worries about what you're doing, then you probably could be doing something a little more for the organization and to fulfill its mission. And so that has stuck with me and kept me a little bit on my toes over the years. He was a perfect mix of encouragement and support. And not always in a, cuddly bear kind of way, but in a way that got you to perform at your best. And so wanted to note the passing of Chip, and he's missed by all of us at IJ. Now, I have a couple attorneys here who unfortunately did not work under Chip, but they did, even if for a very short time, work at IJ while he was chairman of the board. And they are Katrin Marquez and Michael Peña. Now, Katrin has been on before. She works in our Florida office, and we'll hear from her in just a moment with a case from the Sixth Circuit. But no, sorry, Fifth Circuit. Michael's doing the Sixth Circuit. But first, I want to introduce Michael, who is an attorney in our office in Austin, Texas. He is a Texan native. He's a graduate of the University of Virginia School of Law. He's done many things. And one of them, which is unusual for an attorney, is that he was in the Army. And Michael, you weren't in the Army as like, a JAG person out of law school. You were in the Army for a while before law school.
Yeah, that's right. I was a combat engineer, just a regular old enlisted Joe.
And what would you say is you might take from your Army experience and how the Army works as an organization that gives you maybe a different perspective on the legal profession than others might?
Well, I was kind of a barracks, what they call a barracks lawyer when I was enlisted.
Is that like a jailhouse lawyer?
Yeah, I was the guy who knew all the regs, knew all the regulations. So if there was a sergeant who was maybe abusing his authority or something like that, I could say, hey, you don't have to do that. He's not allowed to make you do that. I could quote all the regs and stuff. So yeah, I guess it maybe had its origins there.
Yeah. It sounds like you do well at a town council meeting too.
Yeah, maybe too well. I don't want to get thrown in jail.
That's right. Well, we'll get to that in a moment. So Michael will have a case from the Sixth Circuit in a little bit. Before we get to the meat of the show, I just also wanted to quickly announce we are having our third annual tavern debate that the Institute for Justice is co-sponsoring with the Federalist Society at the eve of the Federalist Society's Western Chapters Conference, which is a big conference they have on the West Coast that I believe some listeners have been to in the past. And the tavern debate, where we will have a lighthearted debate about constitutional government, will be the Friday, the 24th of January, 2025. And we'll put a link in the show notes to this. But if you're in the LA area and would like to come do a little debating, drinking, whatever, with some Institute for Justice attorneys and many other attorneys, please feel free to register. We'll put a link in the show notes. But it is at the Westlake Yacht Club, the Westlake Village, California, which is about an hour up the coast, give or take, depending on traffic, from LA. So we would love to see you if you can make it. But first, Katrin Marquez. So Katrin is in our Florida office, and she is ready to deliver something from her old circuit where she clerked, the Fifth Circuit, and something about Texas judges. So, Katrin, did you know about, I barely kind of knew about this issue, that county judges in Texas are kind of judges, but they're not really judges. They're kind of something else.
I did not know about this. I just learned about it reading this case. Frankly, I still find it very confusing, but here we are. Heading back to Texas, specifically to Maverick County, to talk about its Commissioner's Court. So a Commissioner's Court is a body that manages a county's administrative affairs, and it's composed both of the county's commissioners and, as you just referenced, someone called a county judge. And so in 2023, Maverick County, the Maverick County Commissioner's Court sought to issue certificates of obligation in order to finance improvements to the water and sewer systems. But there was one county resident, Enriqueta Diaz, who did not like this plan. She sought to oppose it and so wanted to force an election by bringing a petition requiring an election. But the Commissioner's Court didn't seem to like this. And when they met to discuss the issue, they decided to issue the certificates without holding the election. This meeting was presided over by the county judge, Ramsey English Cantu, and 4 commissioners. 3 of those commissioners were Commissioners Rios, Ramos, and Ruiz, a lot of alliteration there, and they're defendants in this case, along with English Cantu. So Diaz was at this meeting, she was watching what was happening, and she really quickly realized that they weren't going to discuss her petition. So she started heckling. Now, it's unclear from the opinion exactly what she was doing. They just say she was heckling and she was talking, but whatever it was, English Cantu did not like it and threatened to hold her in contempt. Now, I mentioned that there were 4 commissioners there, but only 3 are defendants. That's because the 4th commissioner tried to stop English Cantu from holding Diaz in contempt, but that did not work. English Cantu ordered Diaz removed from the meeting, and according to Diaz's lawsuit, she was detained outside in the rain for between 3 to 4 hours. While she was detained outside, English Cantu actually had to ask the county attorney if he even had authority to hold Diaz in contempt. And even though it seems like that wasn't particularly clear, he still decided to act on his own and signed a contempt order that sentenced Diaz to 24 hours in a county jail. She ended up not actually serving the 24 hours, but she was booked for this. And so sometime later, Diaz sues English Cantu and the 3 commissioners that didn't do anything to stop this. And so her complaint brought false imprisonment claims against English Cantu and bystander liability claims against the 3 commissioners. So this particular appeal arises from the motion to dismiss, where the defendants bring a bunch of different arguments for why they shouldn't be held liable. It's a long opinion. There's a lot of sub-issues, so we're going to do like a mini Fed courts class. Sorry. But
I mean, that's us every week, so that's okay.
I do love Fed courts. It's a great topic. So I'm going to try to keep this concise, but I think it's best probably to start with English Cantu's arguments for why the claims against him should be dismissed. So his first argument is sovereign immunity, which, as a reminder, is a legal doctrine that protects the government from being sued without its consent. This case specifically is about 11th Amendment immunity, which establishes that states, not municipalities, are immune from being sued in a federal court without his consent. So English Cantu is saying, hey, under Texas law, Texas judges are an arm of the state, so I'm part of the state. You can't sue me. And so to support his argument, he cites to a bunch of cases that say, that's right, Texas judges have sovereign immunity. But as we were chatting about earlier, county judges are kind of weird. They're not normal judges. They're not established by statute. They're established by the Texas Constitution. And unlike the other types of judges that those cases are about, he has more of a judge-administrator role, and his role, at least as to these claims, is within the commissioner's court. Yeah. And their purpose is to handle county business.
He's basically like a county executive you'd have in most states, or a mayor, but at the county level.
Yeah, to me it sounded a little bit like a city manager, but to be honest, I'm not really sure. I'm still very confused.
I think he sits as a judge in other capacities, but for this, it was definitely like a mayor.
Which is part of what makes it confusing, because he's claiming he's a judge, but also maybe not. It's very strange. So for the sovereign immunity argument, because this is weird, the court actually looks to a 6-factor test and goes through each of the factors to determine whether or not he would be entitled to sovereign immunity. So one of the factors is whether the state law views the judges as an arm of the state. And here the court finds that Texas does not, because under the Texas Constitution, he works for the commissioner's court, and the commissioner's court is part of the county government. He is overseen by them. And so they're like, well, this factor weighs against sovereign immunity. Factor 2, which the court repeatedly says is the most important, is the source of funding. And his role as a county judge is funded through the commissioner's court, not through the state. It sets its salaries, it sets his salary and his other monetary allowances, so that also weighs against him. The third and fourth factors are the degree of local autonomy and the focus on local problems. And again, this role that he's functioning is within the commissioner's court, and it has the authority over administering county matters like the budget. So again, nope, doesn't sound like you're part of the state, you're part of the county. The fifth and sixth factors are the least important, and they have to do with whether he can be sued or can sue in his role, or whether he can hold property in his role. The parties don't really argue it, and frankly, all of the other factors are so clearly in favor of him not being a state official and being a county official that the court doesn't really discuss it. But it does make the clear determination that, hey, he is not entitled to sovereign immunity because he is a local official, not a state official. So with that argument failing, he turns to judicial immunity. Hey, I'm a judge. Judges get absolute immunity. That argument also doesn't really work. So he emphasizes the fact that his title is judge and that the title of the commissioner's court is court. But the problem is that titles don't actually determine the analysis. You look at the function that these people serve. And so he says, well, even if the titles don't matter, when I held her in contempt, that's a judicial function. So I'm a judge, I get judicial immunity. And so the court again turns to a multi-factor test. Now, he does win on the first factor, which is whether the act being complained about is a normal judicial function, because holding people in contempt of court is something judges usually do. But he fails on the other three factors, which all turn on the exact same question, which is whether the commissioner's court is a court of law. Hint, it's not. Again, the Fifth Circuit looks to the Texas Constitution and sees that the Texas Constitution tasks the commissioner's court with managing county business. And it also notes that specifically in the agenda for this meeting, there was nothing judicial. It was all largely administrative. So even if he does serve a judicial function in some of his other work, here he was acting as an administrative official and not as a judge, so he's not entitled to judicial immunity. And so with sovereign immunity out of the way and judicial immunity out of the way, we go to our old foe, qualified immunity. And so here he argues that the claim needs to be dismissed because it wasn't clearly established that he lacked authority to hold Diaz in contempt. And so regular listeners probably know that generally, under qualified immunity, government workers can be held accountable for violating someone's constitutional rights if a court has previously held that it was clearly established that those precise actions were unconstitutional. But here the analysis is a little bit different, because here the Fifth Circuit focuses on another part of the analysis, which is the fact that qualified immunity bars liability when the government official is performing a discretionary function. And so even before you get into the qualified immunity analysis, you need to figure out whether the acts are within his discretion. And here the court finds that they were not. Again, it looks to state law, this time to the Texas Local Government Code, which says, quote, "The commissioner's court shall punish people held in contempt." The problem is he is not the commissioner's court. He is a member of the commissioner's court. He is the county judge, but only the commissioner's court as a whole has that discretionary power. He does not. And here, he acted without the commissioners, he acted on his own, and he didn't have the authority to punish Diaz. And so because of that, this isn't looking very good for him, but they try to make the argument that, hey, even if he didn't really have the authority, it wasn't clearly established that he didn't have the authority. So he still shouldn't be held liable. But luckily, the Fifth Circuit is not falling for that. It considers whether it needs to be clearly established that he lacked authority, and there it departs from the Fourth Circuit, which has previously held that you it needs to be clearly established that someone lacked the discretionary authority. And it's very good that the Fifth Circuit did this. I think it's clearly correct. They specifically make a point that I think for regular listeners will make a lot of intuitive sense. So they say that considering the broad reach of qualified immunity in protecting officials from claims, even when they have violated rights, we see no justification for extending this immunity further. I think that's great, and I think it's especially important since oftentimes circuit courts tend to extend the clearly established analysis to areas where it doesn't apply. One example of this is probably in the context of municipal liability, where a lot of circuits, including the Fifth, have said that the clearly established standard applies in municipal liability, even though the Supreme Court has said that it does not. So I think this holding really is part of what makes this case so important, that it's showing, hey, you can't import this part of the analysis that makes it more difficult for plaintiffs into an area where it doesn't belong. So he gets no sovereign immunity, no judicial immunity, and no qualified immunity. But remember, he's not the only defendant. We also have the commissioners who are being sued because they failed to intervene. So Diaz is saying, hey, you have bystander liability because you knew he was doing something unconstitutional and you didn't stop it. Here, however, they are granted qualified immunity. And again, it's because of our old foe, the clearly established standard. So even though the Fifth Circuit has recognized the right against false imprisonment is clearly established, it says that it hasn't recognized that in the context of bystander liability for all government officials. So there is case law that law enforcement officials have a duty to intervene, but not other government officials. So it doesn't extend to the commissioners, and they wouldn't have been on notice that they had that duty. So they do get qualified immunity, which I don't love. I also don't love that the court specifically doesn't establish that there is bystander liability for other government officials. But, 3 wins with English Cantu is pretty good considering.
Michael, your thoughts?
Well, my first reaction to this case was I just thought it was kind of funny because it's a panel of judges telling a judge that he's not really a judge. So I think that's just great. But yeah, I wonder if that was a big blow to the guy's ego. But
and then the plaintiff is also a former county judge. It's like judges all over the place who aren't even judges sometimes.
Yeah, but I thought the qualified immunity analysis was interesting because that threshold issue of whether it was even in the official's discretionary authority, sometimes you don't even see that in case opinions on what the legal standard is. So it's really easy to forget about. And I think this is the first case that I've seen that threshold issue be dispositive. And so that was kind of clarifying for me because it didn't really make sense to me before I read this opinion. Because, if you're asking as a threshold issue whether it was in the discretionary authority, it seems like you could resolve lots of cases that way. Like does a police officer have the discretionary authority to shoot an unarmed suspect, when they're not doing anything violent? It seems like that type of issue would just get settled under the clearly established prong and not under the threshold issue. But to see it resolved that way here, I thought was interesting and clarifying.
I had the exact same thought about what you just said, Michael, about authority that someone has, whether it's in their discretion or not. And it seems like a lot more could be done with that, or maybe I'm missing something. But, the foundational case for Section 1983 cases like this is Monroe versus Pape from 1961, which we talked about on Bound by Oath a season ago. So we'll put a link into that episode in the show notes if you guys want to listen to it. But in our documentary podcast. But in that case, the Supreme Court established that even if an officer does something that's not allowed by state law, so outside of outside of what would be legal under state law, he still can be liable under the Constitution, because the theory was that, well, if it's unlawful under state law, it's like not even covered by Section 1983. And that seems like this. I mean, the cop was doing something that he wasn't allowed to do as a cop, but because he's wearing a badge and he has that authority, he gets liability. And so it seems like in this case, I mean, that wasn't a qualified immunity case, of course. So maybe that kind of area of qualified immunity has just never been, reconciled, I guess, with the underlying theory. But it does seem like we read about a lot of qualified immunity cases where the police are doing something they're not allowed to do under their own regulations, and yet they still can get qualified immunity, and they often do. Katrin, can you square the circle?
I can't, other than to just say they keep getting it wrong. I mean, I think part of it has to do with the discussion that's had here, where they talk about like, hey, we know we're departing from the Fourth Circuit in doing this. And I think it's just, again, a different part of the analysis is kind of being imported into this threshold question, because I think especially with police, people don't like questioning them. And so you're like, well, maybe it's not obviously within their discretion, but also it's a hard job and you're making last minute decisions. So,
right.
I mean, the sad thing is qualified immunity doctrine as a whole is kind of a mess.
Right. Well, and I suppose in this area, what this quote judge did was just so outside of what he's allowed to do. And I mean, I can't think of anyone who like runs a city council meeting who's allowed to find someone in contempt. I mean, they can send the guard to arrest them for being disorderly, and then they're prosecuted in the normal course of business. But they're not just putting contempt, which is kind of contempt itself is kind of an end round around the whole judicial that I guess we allow, because disrupting the courtroom is such something we want to take special care to stop. But this wasn't a courtroom.
Yeah, and I think part of what makes it interesting here is that, I guess under Texas statutes, again, the commission can do that, but he himself cannot.
Right.
And he was essentially doing this, even though a member of the commission was telling him, hey, do not do this. So I think here it was very clear that he wasn't acting how he should. Though, of course, he claims, hey, it wasn't clear. I had to ask the county attorney. So even he clearly had some doubts whether he could do this or not.
Well, we'll go now to another council meeting of one kind or another. And here we have more kind of the gadfly type of criticism coming at the people in power. But we have a similar results, although kind of a longer story than what Katrin just told. And that's this Sixth Circuit case that Michael's going to tell us about, Blackville versus Nocerini, which I probably mispronounced.
I think it's Nocerini, but
I think you're right. My Italian isn't up to scratch.
Yeah, mine either. I actually had to look that up. But yeah, so today I'll be talking about Blackwell versus Nocerini. This is a First Amendment retaliation case out of the Sixth Circuit on appeal from the Eastern District of Michigan. The city officials filed a motion to dismiss the lawsuit based on qualified immunity. The district court denied the motion to dismiss, and the Sixth Circuit affirmed. Now, because this is an appeal on a motion to dismiss, the court has to accept all the allegations in Blackwell's complaint as true and view them in a light most favorable to him. So just keep that in mind as I recite the facts. But the facts of this case occurred in Michigan, in the city of Wayne, in 2018 and 2019. The plaintiff Blackwell called for the termination of the city manager, Lisa Nocerini, during the public comment period of city council meetings. And then Nocerini told the police chief, Ryan Strong, about 2 alleged incidents involving Blackwell from 2016. The first was that he once watched her and may have taken photos of her while she was publicly campaigning. And the second was that he once followed her for a few blocks as she drove to City Hall. And she also mentioned that Blackwell often loitered with others in the City Hall's parking lot after city council meetings. So Chief Strong asked Lieutenant Carter to investigate Blackwell. Carter then asks the prosecutor's office to file a criminal complaint, and Blackwell was charged with 2 offenses. The first was disturbing a lawful meeting, and that charge was dismissed before trial. And the second was stalking, and for that charge, Blackwell was found not guilty after a bench trial. So Blackwell files a lawsuit under Section 1983 against Notarini, Strong, and Carter, alleging First Amendment retaliation and other claims. The city officials file a motion to dismiss. Blackwell consents to dismissal on some of the claims, but not the First Amendment claim, and the district court sides with Blackwell on that claim. Now, there was a threshold issue on appeal about jurisdiction and whether the appeal was timely or not. That the issue turned on analysis of the Eastern District of Michigan's local rules and how they intersect with Federal Rule of Procedure, Civil Procedure 59, and Appellate Rule 4. I'm not going to spend any time on that because it's not that interesting.
Those listeners who loved our recent 7th Circuit episodes and all the jurisdictional stuff will love that part of the opinion. So make sure you click through and read.
Yeah, but long story short, the court found that the appeal is timely and that it has jurisdiction. So moving on to qualified immunity, this is going to sound familiar after hearing what Katrin just said, but he has to show 2 things. He has to allege facts plausibly suggesting that the city officials violated the First Amendment, and 2, that the law clearly established that violation. So first we'll talk about whether there was a First Amendment violation at all. And in the retaliation context, he has to show 3 things. The first is that he engaged in protected speech. The second was that the defendants took an adverse action against him. And the third was that the protected speech caused that harmful action. So only the third element was disputed here. So the question is, did Blackwell's complaint plausibly allege that his criticisms of Notarini caused the city officials to convince prosecutors to charge him? And it's a but-for causation standard, meaning would the defendant still have taken the harmful action if he hadn't spoken? Now, this is tricky in the prosecution context because prosecutors enjoy absolute immunity under Section 1983 for prosecutorial judgments, and that's why Blackwell had to sue others in the chain of prosecution. And it's tricky because the actors who take the adverse action, the prosecutors, will generally be different than the defendants who allegedly harbored the retaliatory intent, and that's the investigators who induced the prosecution. So to bridge the gap between one person's animus and another's action, the Supreme Court has held that causation in this context requires plaintiffs to prove that the prosecution lacked probable cause. And as we know, probable cause isn't a high bar, but the city officials didn't argue that they met the test for the disturbing a meeting charge. It was only the stalking charge. So the Sixth Circuit then goes on to cite the Michigan definition of stalking, and that left the question of whether there was probable cause to charge Blackwell with stalking under Michigan law. And the answer to that question might depend on what evidence the district court was allowed to consider. Because here, the city officials attached 3 exhibits to the motion to dismiss. The first was a timeline of events that Notarini drafted. The second was Carter's police report. And the third was the criminal complaint against Blackwell. And this is important evidence because it could undermine Blackwell's argument that there was no probable cause to charge him with stalking. For example, the police report said another employee told Chief Strong that Blackwell threatened to slash Notarini's tires after a meeting. But the problem is that under Rule 12b-6, a court should typically limit itself to the well-pleaded allegations within the complaint's 4 corners. So if a defendant attaches evidence to a motion to dismiss, a court has 2 options. It can either exclude the evidence or it can consider the evidence and treat the motion as a motion for summary judgment under Rule 56. But there's 2 exceptions to that rule. The first is that when a complaint refers to the exhibit and the exhibit is central to the plaintiff's claims. And I'm sure Katrin is probably familiar with this from her days as a law clerk. Yeah, but this comes up a lot in like breach of contract cases. For example, a plaintiff who asserts a breach of contract claim can't prohibit a district court from considering the whole contract merely by omitting the contract from the complaint. And the city officials argued that that exception applies here because the complaint refers to the police investigation and the prosecution. So the 3 exhibits are central to the retaliation claim. But the court rejected that argument and said Blackwell's claim doesn't depend on these exhibits because his claim can succeed no matter what statements Carter put in his police report or what statements the prosecutor put in the complaint. Instead, it'd be more accurate to say that the exhibits are central to the city officials' defense rather than Blackwell's claims. And it was also true that Blackwell disputed many of the statements in the exhibits. So the city officials were essentially asking the court to disregard the normal presumption of truth that courts must give to a complaint's well-pleaded facts. And the second exception is that courts can take judicial notice of public records, but this exception only allows a court to conclude that the record exists, not that all the information in the record is true. And the defendants didn't want to use the exhibits for a narrow purpose to confirm some undisputed fact, such as the fact that the prosecutors charged Blackwell with crimes. They wanted to use the exhibits to establish the truth about what Strong and Carter learned during their investigation, but those facts are subject to dispute, so the court can't consider them at this stage. So without considering those three exhibits, the court held that there was no probable cause for the stalking charge, and that's because no reasonable and prudent person would believe that any of Blackwell's three alleged actions qualified as harassment, or that the actions could have reasonably caused Notarini to suffer emotional distress. Two of those actions occurred in 2016, and that was a couple of years before the city officials pursued the stalking charge. And the first of those incidents, driving two cars behind her, that apparently happened only once, and the court noted that many people drive on that road where City Hall is. And the second was watching her in public and taking photos of her. And again, this happened only once, and the court noted that it's not unusual for citizens to watch public officials campaign in public spaces. And the long gap between those incidents, and it undercuts the claim that Blackwell engaged in a pattern of conduct revealing a continuity of purpose to harass Notarini. And the third incident, gathering in the City Hall parking lot, I mean, he was lawfully present on public property, and no reasonable person would suffer emotional distress from his mere presence in a public place. So the Sixth Circuit held that, or stated that it was understandable why the state court found that Blackwell hadn't done anything out of the norm. But next there was causation, because the city official, even if all that's true, even if there's no probable cause, the complaint doesn't plausibly allege that they pursued the stalking charge because of Blackwell's political speech. But the court reasoned that a complaint that pleads the lack of probable cause goes a long way toward pleading causation. And Notarini alerted Strong about Blackwell pretty soon after he criticized her at the meeting. So the lack of probable cause combined with a short time gap is enough to allege causation at this stage. And one small thing before moving on to the next inquiry in QI analysis was that that Blackwell's complaint needed to allege facts that connected each official to the First Amendment violation. And that's important because it's not clear why the other two defendants would have a motive to retaliate when Blackwell's criticisms didn't target them. But the Sixth Circuit says there's no need to resolve that question because the city officials never made that argument, and so they forfeited it on appeal. So moving on to clearly established law, as we know, a right qualifies as clearly established only if any reasonable official would have recognized that the challenged conduct violated that right. And this test usually requires plaintiffs to identify the right with a high degree of specificity. And in the First Amendment context, plaintiffs can't rely on the more general right to freedom of speech to rebut a qualified immunity defense. So what is the appropriate level of generality in this context? And the Sixth Circuit took that as an open question that was up for debate. Because remember that Blackwell must prove the absence of probable cause, but probable cause turns on the totality of the circumstances. And in the Fourth Amendment context, a plaintiff must usually identify cases that found a lack of probable cause in similar circumstances. And plaintiffs can only avoid this requirement in the rare, obvious case in which any reasonable official would have recognized the absence of probable cause, even if there was no on-point precedent. And Blackwell's briefing didn't even attempt to identify factually similar probable cause case law. And that would be tough to show. I mean, it's doubtful that there's a case with a holding that there was no probable cause for stalking where the defendant drove two cars behind a victim one time, took photos during a public campaign, and loitered in a City Hall parking lot. And even if there was something factually similar, a court might try to split hairs over the facts and distinguish it. You know, a court might say, well, in that case, he drove three cars behind. In this case, it was two cars behind, so it's not clearly established. But then the Sixth Circuit says, well, on the other hand, the First Amendment retaliation claims are different from Fourth Amendment claims because the Fourth Amendment adopts an objective test that renders an officer's motives for an action irrelevant. But retaliatory prosecution claims require a defendant to have harbored a retaliatory motive for a prosecution and to have acted with subjective animus. So maybe Blackwell should only have to prove that the officers harbored retaliatory intent and that they acted without probable cause, without the need to identify similar probable cause cases. And that might make sense because wouldn't any officer recognize the unlawfulness of pursuing a prosecution for the purpose of punishing speech protected by the First Amendment? But the Sixth Circuit says there's no need to resolve the debate at this stage because even under the more defendant-friendly test, it would have been obvious to any reasonable officer that the 3 alleged incidents didn't establish probable cause. So Blackwell didn't need to identify analogous probable cause case law to get past the pleading stage, and the court saved for another day the question of whether Blackwell must do so at the summary judgment stage. So that's Blackwell versus Nocerini, and I'll pause there.
Katrin, your thoughts?
What is going on at municipal meetings? Why does this keep happening? It's actually really funny because when I was looking into what case I wanted to do for this, there were a lot of options in this area. There's been a lot of cases in December having to do with
just in the last month, you're saying?
Yeah, just in the last month. That's putting aside all our own work in this area, which IJ does a lot of. So it's just fascinating to me how much retaliation there is from municipal bodies that oppose some type of public criticism. So it's kind of like the big picture concern, which obviously ties into a lot of the work that IJ does. But I also just, what can I say? The lawyerly instinct in me is like, the jurisdictional questions here are fascinating to me. Like, yes, they're not as interesting as all of this other stuff, but I think part of the reason I find them interesting is because, like Michael said, his case is at the motion to dismiss stage. There's a lot of specific procedural standards at the motion to dismiss stage. So is mine. And these are interlocutory appeals. And I find that funny because sometimes it really feels like government tries to get around jurisdiction in weird ways. So in Michael's case, I think the appeal is totally appropriate. But for example, in my case, one of the issues I didn't discuss was the fact that they also tried to appeal a Monell liability claim saying, hey, we can do this, when it's very clear that there's no actual jurisdiction for that.
That's liability against the municipality, right?
Yeah, because obviously you can only appeal final orders, as Michael was referencing, and that was not a final order.
Right.
And so the fact that this issue, in addition to just the substantive problems with municipalities constantly doing this, the fact that just from a litigation perspective, these types of very procedural in the weeds issues also keep coming up is, I find really interesting.
Yeah, all the thicket of jurisdictional stuff that Michael rightfully didn't go into detail on is just shows you what the landmines can be with jurisdiction and appeals. And maybe the attorneys on both sides could have done a little bit more homework. I mean, the judges kind of bailed them out here, going through step by step, like why. I mean, they really got into the weeds on the local rules and the appellate rules on how this appeal could proceed. I also am kind of fascinated by the part that Michael raised where they said, well, no one briefed this, so we're not going to talk about it. But that's kind of the ultimate point in this case, is that unfortunately, because of prosecutorial immunity, he had to sue these other these cops, and they don't really allege that they are trying to commit First Amendment retaliation, but it seems like he would be successful against them for a Fourth Amendment violation, like you said, Michael, because there's no probable cause, even if it's not for a retaliatory motive. And so you wonder, after the motion to dismiss stage, if I'm the government's lawyers here, I'm going straight to summary judgment with as little a record as you want to worry about, because then you can raise this point about causation for the First Amendment claims.
Yeah, and it can be tough kind of ascertaining what someone's motive really is too, because Ryan Strong was actually the second police chief. The first one that she apparently asked to charge him resigned, and so Ryan Strong was the interim chief. And so it was alleged that he induced this investigation because he was trying to get on the good graces with the city manager and become the permanent police chief. So maybe his motives were bad, but are they retaliatory for political speech? It's like a different kind of motive.
It's interesting because it feels like in a lot of these cases, it ends up being like you have to plead that there's some type of conspiracy between everyone in order to do this, which, I mean, municipalities are small bodies. There are friendships within them. So I don't think it's an unreasonable thing to plead, but it is interesting sometimes trying to make those connections.
Right. And for listeners who are interested in the cases that we're doing at IJ about city council meetings and related topics, we'll put a couple links. Of course, I'm sure most listeners know about our case Gonzalez that went to the Supreme Court last year, which was about a city councilor at a council meeting then suffering retaliation. But we have other cases about people actually at the city council meeting and in related contexts. So we'll put a few links there if you want to check that out. But thank you, both of you, for coming to this meeting. I don't think we had any hecklers. There's no contempt, so no one's going to be hauled out in the rain. But nevertheless, Happy New Year. Thank you, Katrin. Thank you, Michael. Thank you, all of you, for listening. A Happy New Year to you. And please be sure to follow Short Circuit on YouTube, Apple Podcasts, Spotify, and all other podcast platforms. And remember to get engaged.